On the lines, Winston Shrout. Winston Shrout Solutions in Commerce, coming up on September 28th from 10 a.m. to 12:30 p.m. Winston is going to be holding one of his very informative webinars, this one titled Operating in Bankruptcy. Make sure and go to www.wssic.com for more information. Winston, always a pleasure to speak with you, sir. How are you doing today?
Well, I'm doing just fine. How about yourself?
Well, much better now, sir. It's always a pleasure to be online with you. You really do such an amazing job on taking care of your gardening students and all those that are getting ready to till the soil of empowerment. So, bravo to you.
Okay.
Yeah. And so here we are. We're talking about operating in bankruptcy. Very provocative term, sir. Are we talking about personal bankruptcy, the bankruptcy of the United States? Who's bankrupt here?
Well, everybody's bankrupt.
Oh, no.
Well, I'll explain that a little bit further because that sounds perhaps a little bit outlandish. However, if you go back in history, however far back we think the Garden of Eden story was, if you recall the story, the man and the woman had agreed to certain conditions which they broke, and in consequence of that, the penalty that had been affixed for the violation was put off into the future. And so in consequence of that, they were put into a different jurisdiction. And while they were in that jurisdiction, they had the chance to reorganize their debt, or as we say in religion, to repent. But in any event, they had a chance to reorganize the debt so that it could be put off, the consequences of that debt could be put off into the future. Now, when we get down to our more modern times, as it were, a lot of people don't understand that the United States of America or the United States Incorporated or whoever, just whoever we think we are, we've always been in bankruptcy. And that was, if you look closely at the Articles of Confederation, they took over the debt of the colonies at that time in order to protect the colonies from the creditors. And so then we had the Articles of Confederation, which rolled over into the Constitution for the United States of America, which was simply another a reorganization or another bankruptcy. Now, since that time, we've been in and out, and there are certain circumstances, historical that we could talk about, which we really don't have time today. But just to get to the point over to the people, that we are, in fact, operating in bankruptcy in this country and always have been. So when we talk about bankruptcy, you just have to understand that mankind is in bankruptcy, our country is in bankruptcy, along with all the other countries on the planet. And then we get to start talking about, as you referred to, personal bankruptcy, or we might start to talk about individual bankruptcy. Those things need a little bit of explanation, which I'll quickly try to do here.
Yes, sir.
But what it amounts to is that since 1933 and since the introduction of birth certificates and all that stuff that we've talked about in the past, you understand that a person is a corporation. Corporations are created to carry debt. Hence, they are always in a reorganization of the debt. So consequently, all of the corporations, including your all-capital letter name, is in a continuous bankruptcy. Now, that's different than an individual bankruptcy, which would probably find itself in the common law concepts. But since we're no longer in common law, we're only talking about fictions and persons and those kind of things. So it's important for people to realize that the corporation that kind of looks like or sounds like your name is actually involved in a reorganization, bankruptcy, which is fostered by the United States government in the form of a Chapter 11 reorganization. So with all that said, Go ahead and ask your next question.
Wow. Well, so in this, sir, in the idea of bankruptcy, of course, individuals, look at it as shameful individually, but we hear corporations and businesses go into bankruptcy and come out of them and use it as a tool for survival. In your analysis of operating in bankruptcy, what is your view of how bankruptcy, is it something that can be helpful to individuals? It's something to stay away from. What is how do we approach this whole notion?
Well, let me give another word here that would be very helpful, and that is bankruptcy protection. Bankruptcy protection.
True.
So we usually say bankruptcy, but what we're really talking about is protection using a bankruptcy. Now, what we're trying to do is to protect the assets of the individual from the attacks of some creditor upon the corporate entity. Now, let me throw some things at you here that might sound kind of goofy, but upon close analysis, the United States itself is actually operating a Chapter 11 of bankruptcy as debtor in possession. In other words, the debtor in possession in a Chapter 11 is acting as the trustee.
Okay.
Now, as I've said before, all corporations are the same entity. They're all joined at the hip. And so the United States Incorporated, the state of California, IBM, Safeway, and John Doe, in all capital letters, is all the same. It's the same entity. Now,
yes,
that entity is, in fact, the debtor in possession in the Chapter 11. Now,
okay.
the Chapter 11 is being operated against the creditors. The purpose of a bankruptcy, now this is going to throw people for a loop, I guess. The purpose of a bankruptcy is so that the debtor can discover the assets of the creditor. It's not the other way around. It's the debtor who's actually the aggressive party in a bankruptcy. So in our Chapter 11 that is being operated, the corporate entities are trying to discover the assets of the creditors, who are in fact the people, and then upon that discovery, the debtor in possession will try to find some way to seize the assets of the creditors. Now...
Okay, so that's one of your things where day is night and night is day.
Yes, in commerce, you always have to look at things as if you are in a mirror situation. And so things are not always as they appear. And so when you start to talk about bankruptcy, people look at it from one point of view, but from the correct position, everything changes in the mirror. So who has assets? Debtors or creditors? Well, the creditors have the assets, obviously. Yeah,
right.
Sure. And so what does the debtor want then?
Some of that.
Some of that, or all of it if they can get it.
Yes.
So then the purpose then of this Chapter 11 is so that the debtor in possession can find ways to seize the assets of the creditors, and they do it every day of the week in the form of traffic fines, court judgments, taxes, on and on and on it goes. But that's the technology that's in use at the present time to strip the creditors of their asset for the benefit of the debtor in possession. Now, with all of that said, then perhaps we could take a look at bankruptcy protection. Now, we have various styles or types of bankruptcies that are available to individuals. The primary ones are Chapter 7 bankruptcy protection or a Chapter 13 bankruptcy protection, or even if the numbers get big enough, then you start to talk about a Chapter 11 bankruptcy protection, which is a little bit different. Now, remember, it's not the man or woman that's bankrupt. A man or a woman that is living and breathing, can walk or talk or operate a computer is not bankrupt. What is bankrupt? Well, it's the straw man, or it's the corporate entity that has been created. So that's what goes bankrupt. As a matter of fact, one of our friends, he did a Chapter 7 for a particular reason, which we'll have time to cover at the webinar. But anyway, he put himself in such a position in the Chapter 7 that the trustee asked him to fill out a B-10 form as a creditor. Now, the man was the creditor in the bankruptcy of the straw man. Now, that's kind of a weird circumstance. Takes a little bit of thinking to get through that, but we'll be analyzing that situation at the upcoming webinar. But the key for everybody to remember that these Chapter 7 and Chapter 13 circumstances are bankruptcy protection so that the creditor can protect their assets.
Wow.
And we're going to have a hard time with this. I know we are.
Whoa. But you know what? That's going to be one of these kind of lectures, Winston, where I can imagine there's going to be a lot of aha moments when people sit down. So. Oh, yes, absolutely. Because you are so good at breaking down the complex for the common, I know people are going to see through and have just a whole new train tracks to discovery for new technologies for what they need. On the lines, Winston Shroud, Solutions in Commerce, coming up on September 28th from 10 a.m. to 12:30 p.m. Webinar is Operating in Bankruptcy. And you just heard, we've only been speaking for around 10 minutes, but hello, that's pretty heavy duty. And so this is going to be an amazing webinar. Let me tell you that you can call and register using this phone number, 971-333-1005, 971-333-1005. The cutoff time for registration by phone is September 26th at 6 p.m. Pacific Standard Time. That's coming up on Thursday. Or for online registration, go to www.wssic.com. The online registration deadline is September 27th at 2 p.m. So give them a call, 971-333-1005, or go online at www.wssic.com. Sign up for Winston's upcoming seminar, September 28th from 10 a.m. to 12:30, Operating in Bankruptcy. So, Winston, wow. We have a upside-down formula where the debtor in possession is actually the trustee coming after us, the creditors, using this fiat currency to be able to collect even more of those. It sounds like such a precarious position, and there are so many people operating this unbeknownst to them. What would it mean for somebody to come into this knowledge? How could they use this to better their position?
Well, it would be, in the extreme case, it would be for asset protection. And we have many occasions, where this is the exact thing we're dealing with. One of the things that a lot of people don't realize, and that is that while you're in a bankruptcy, you can file a civil case. It's called an adversarial proceeding. Now, I've noticed, especially like with mortgages and some of these things, that people have been dealing with and have been getting nowhere in their local state courts. And I hear this constantly. The judges simply will not uphold the law in regards to some of these situations. And so I have suggested to several people that they actually go and file either a Chapter 7 or a Chapter 13 for the purpose that you can move your civil dispute directly into the federal court in the bankruptcy court.
True.
Now, probably, you'll get a whole lot better service, out of that federal suit than some of the state things that you're facing. And so that's a good avenue, for many people to pursue who are having so many problems in the state courts. And why it is, I don't know, but my only conclusion is that somebody's getting paid out in the parking lot. But I can think of no other reason why they act the way that they do. But in any event, some of these matters can be removed into the federal jurisdiction by simply filing a bankruptcy and then going and suing a civil case right there within the bankruptcy.
And so why do you think federal judges would not act like some of these state judges do? Or is that just we just got to go and see if they are going to actually uphold the law? It's just a test.
There's a couple of reasons. First off, most federal bankruptcy judges would really like to be a United States district judge. I mean, that's their next step up. Mm-hmm. And so they're not quite so prone to be user unfriendly. And they don't want a whole lot of problems within their bankruptcy court because that would stop them from moving up to a federal judgeship. So I would think that there's a certain amount of motivation, from that respect. Now, I'll refer people to our website, which is called Winston's Watch. I mean, we have a section on there called Winston's Watch, where I posted a judicial determination that basically outlawed MERS. And that
what?
Yeah. It overturned MERS. And that actually came from a bankruptcy court, a federal bankruptcy judge. Huh. And so that was very, very significant, and I thought it was very interesting that it actually came out of a bankruptcy court rather than the United States District Court itself. However, the effect of that has been immense across the country for those who are aware of it and who have the competency to use those kind of precedences.
Well, it is very interesting, sir, that bankruptcy is one of these limited areas of law that is just the federal jurisdiction and not the states. And so I guess that really must say something to people that are studying the law, that what you are talking about, that our government in bankruptcy, that this is their venue, their jurisdiction, because, well, they kind of started this mess.
If people would go and make a detailed study of bankruptcy itself, I think they would be well served to do so, because there's many things that can be solved there that perhaps can't be solved in some of these other places. Now, also, and I think we're kind of running down on our time here, but I wanted to mention that one of the elements that we'll be speaking of at the webinar is something that's known as involuntary bankruptcy. Now, this is a very aggressive move, and that is if you have a debtor who owes a certain amount, then you can put them into a involuntary Chapter 7 for liquidation.
Wow.
Now, in the past, I have not brought this up to people because, like I say, it's very aggressive. It's very difficult. The competency level of the party who would attempt that should be very high.
Yes.
And so I have had reservations about even mentioning it, but I think maybe the time's the appropriate to bring that issue up. So that is one of the elements that we'll be going into at the webinar, but it's a very aggressive thing. For instance, we have people who are holding commercial paper, true bills. They're holding commercial liens. They're holding other things. They're always saying, "How can we collect this? How can we collect this?" I said, "Well, okay, let me open this up a little bit. And if you think you're competent enough to attempt this, then here's how you would go about doing so." Mm-hmm. And so it's very aggressive. It's not for the beginners, but we'll be at least alluding to that to give the people a direction they might go if they want to pursue that.
Well, always your webinars just absolutely jam-packed. A jam-packed 2.5-hour webinar coming up on operating in bankruptcy. It sounds really fascinating. Is this one of the first times that you've gone into this, Winston? Is this? Yeah.
No. We've spoken of bankruptcy. Well, we're in bankruptcy all the time.
Right.
And so, no, it comes up quite often.
Right.
What we have is that seem like we have a fresh crowd coming around all the time. We have a certain evolution, and so we have new people coming on all the time. And then, but rather than have to go back and sift through so many of the things we've done before, I thought I could go ahead and focus in on this a little bit more definitively, for some of the ones, so they can have a kind of a compact picture of it. But no, we speak of bankruptcy all the time.
Oh yes, definitely you do. I guess, like you said, drilling down into it, talking about it being a defensive and an offensive tool is fascinating, and I cannot wait for this upcoming webinar, Operating in Bankruptcy. Folks, it's going to be on September 28th, 2013 from 10 a.m. to 12:30 p.m. To register by phone, call 971-333-1005. That's 971-333-1005. You can also register online. Registration closes September 27th at 2 p.m. That's on Friday. Phone registration closes Thursday, 6 p.m., both of those Pacific Standard Time. That's Thursday, September 26th for the phone, September 27th for online registration. So do it now. Because this webinar, Operating in Bankruptcy, is going to be quite a update, going back to some foundations that Winston has always talked about, but wow, really going to give you hands-on strategies, methodologies for you to understand the world that you are in. Well, Winston, congratulations on all that you do. You are an archangel down here helping people make correct choices, and I just appreciate so much your faith in humanity to continue to do the work that you do.
Well, I wouldn't call me an archangel. I might be an arch hillbilly, but aside from that, we'll go with something there.
Well, that is absolutely wonderful, sir. Look forward to your webinar, and always a pleasure speaking with you, sir.
Well, same to you. Thanks very much.